The politics of Italy is conducted through a constitutional republic with a multi-party system. Italy has been a democratic republic since the 2nd of June 1946, when the monarchy was abolished by popular referendum and promulgated on the 1st of January 1948. The executive power is exercised collectively by the Council of Ministers, which is led by the Prime Minister, officially referred to as President of the Council. Legislative power is vested in the two houses of Parliament primarily, and secondarily on the Council of Ministers, which can introduce bills and holds the majority in the Parliament. The judiciary is independent of the executive and the legislative branches. It is headed by the High Council of the Judiciary. The President is the head of state, though his position is separate from all branches. The current President is Sergio Mattarella and the current Prime Minister of Italy is Matteo Renzi. Government. Article 1 of the Italian Constitution states Italy is a democratic republic founded on labor. Sovereignty belongs to the people, and is exercised by the people in the forms and within the limits of the Constitution. By stating that Italy is a democratic republic, the article solemnly declares the results of the constitutional referendum which took place on the 2nd of June 1946. The state is not a hereditary property of the ruling monarch, but it is instead a res publica, belonging to everyone. The people who are called to temporarily administer the republic are not owners, but servants, and the governed are not subjects, but citizens. And the sovereignty, that is the power to make choices that involve the entire community, belongs to the people, in accordance with the concept of a democracy, from the Greek demos and kratia. This power, however, is not to be exercised arbitrarily, but in the forms and within the limits established by the rule of law. Head of state is the head of state. The President of the Republic represents the unity of the nation and has many of the duties previously given to the King of Italy. The President serves as a point of connection between the three branches. He is elected by the lawmakers, he appoints the executive, and is the President of the Judiciary. The President is also Commander-in-Chief of the Armed Forces. The President of the Republic is elected for 7 years by Parliament in joint session, together with 3 representatives of each region, except for the Aosta Valley, which gets only 1 representative. These delegates are elected by their respective regional councils so as to guarantee representation to minorities. The election needs a wide majority that is progressively reduced from 2/3 to 1/2 plus 1 of the votes after the third ballot. The only presidents ever to be elected on the first ballot are Francesco Cossiga and Carlo Azeglio Ciampi. Mr. Ciampi was replaced by Giorgio Napolitano, who was elected on the 10th of May 2006. While it is not forbidden by law, no president had ever served 2 terms, until the 20th of April 2013, when President Giorgio Napolitano was re-elected. The president cannot hold office in any other branch of power, and the officer's salary and privileges are established by law. Among the powers of the president are the capacity to send messages to Parliament, authorize the introduction of bills by the government, and promulgate laws, decrees and regulations, dissolve one or both houses of Parliament, in consultation with their presidents, except during the last 6 months of his terms, unless that period coincides at least in part with the final 6 months of the Parliament. Call a general referendum under certain circumstances established by the Constitution. Appoint state officials in the cases established by law. Accredit and receive diplomats, and ratify international treaties, after the Parliament's authorization when required. Make declarations of war agreed upon by the Parliament, as Commander-in-Chief of the Armed Forces. Grant pardons, commute sentences, and confer honorary distinctions of the Republic. The President also presides over the High Council of the Judiciary and the Supreme Council of Defense. Usually, the President tries to stay out of the political debate, and to be an institutional guarantee for all those involved in the political process. The President can also reject openly anti-constitutional acts as the guardian of the Constitution of Italy. The President is not responsible for the actions performed in the exercise of his duties, except for high treason and violation of the Constitution, for which the President can be impeached by the Parliament in joint session, with an absolute majority of its members. Legislative branch with Article 48 of the Constitution, which guarantees the right to vote. The people exercise their power through their elected representatives in the Parliament. The Italian legislative branch has rights to declare war with a majority vote. The Parliament has a bicameral system, and consists of the Chamber of Deputies and the Senate, elected every 5 years. The Chamber of Deputies is elected by direct and universal suffrage by voters who are 18. There are 630 deputies, 12 of which are elected in the overseas constituencies. All voters who are 25 on election day are eligible to be deputies. The Senate is elected by direct and universal suffrage by voters who are 25. There are 315 senators, 6 of whom are elected in the overseas constituencies. There are also a number of senators for life, such as former presidents or citizens appointed by the President during his term in office, for having brought honor to the nation with their achievements. All voters who are 40 on election day are eligible to be senators. Executive branch. The Constitution establishes the government of Italy as composed of the President of the Council and ministers. The President of Italy appoints the Prime Minister and, on his proposal, the ministers that form its cabinet. The appointee is usually the leader of the majority coalition that won the election, but it can also be a person instructed by the President to form a national unity government in times of crisis for the nation. Either way, the government must receive the confidence of both houses. So the executive derives its legitimacy from the Parliament, and the great number of political parties forces the Prime Minister to bend to their will. If the majority coalition no longer supports the government, the Prime Minister can be ousted with a vote of no confidence, and a new government must be formed, or new elections scheduled. Judicial branch. The Constitution states that justice is administered in the name of the people and that judges are subject only to the law. So the judiciary is a branch that is completely autonomous and independent of all other branches of power, even though the Minister of Justice is responsible for the organization and functioning of those services involved with justice and has the power to originate disciplinary actions against judges, which are then administered by the High Council of the Judiciary, presided over by the President. The Italian judicial system is based on Roman law, the Napoleonic Code and later statutes. It is based on a mix of the adversarial and inquisitorial civil law systems. Although the adversarial system was adopted in the appeal courts in 1988, appeals are treated almost as new trials, and 3 degrees of trial are present. The third is a legitimating trial. There is only partial judicial review of legislation in the American sense. Judicial review exists under certain conditions, established by the constitutional law, in the Constitutional Court, or Court Costituzionale, which can reject anti-constitutional laws after scrutiny. When the court declares a law unconstitutional, the law ceases to have effect the day after the publication of the ruling. According to Article 134 of the Constitution, the Constitutional Court shall pass judgment on controversies on the constitutional legitimacy of laws issued by the state and regions, conflicts arising from allocation of powers of the state and those powers allocated to state and regions, and between regions, charges brought against the President and, until 1989, the ministers. The Constitutional Court is composed of 15 judges, one of which is the President of the Italian Constitutional Court, elected from the court itself. 1/3 of the judges are appointed by the President of the Italian Republic. 1/3 are elected by Parliament and 1/3 are elected by the ordinary and administrative Supreme Courts. The Constitutional Court passes on the constitutionality of laws, and is a post-World War II innovation. Its powers, caseload, and frequency of decisions are not as extensive as those of the U.S. Supreme Court. Italy has, in November 2014, accepted compulsory jurisdiction of the International Court of Justice. Political parties and elections. All Italian citizens older than 18 can vote. However, to vote for the Senate, the voter must be at least 25 or older. Scandal investigations touched thousands of politicians, administrators, and businessmen. The shift from a proportional to an additional member system also altered the political landscape. Party changes were sweeping. The Christian Democratic Party dissolved, the Italian People's Party and the Christian Democratic Centre emerged. Other major parties, such as the Socialists, saw support plummet. A new liberal movement, Forza Italia, gained wide support among moderate voters. The Alleanza Nazionale broke from the Italian social movement. A trend toward two large coalitions emerged from the April 1995 regional elections. For the 1996 national elections, the centre-left parties created the Olive Tree Coalition while the centre-right united again under the House of Freedoms. These coalitions continued into the 2001 and 2007 national elections. This emerging bipolarity represents a major break from the fragmented, multi-party political landscape of the post-war era. Although it appears to have reached a plateau, since efforts via referendums to further curtail the influence of small parties were defeated in 1999, 2000 and 2009. Regional governments. 5 regions have special charters granting them varying degrees of autonomy. The raison d'être of these charters is in most cases the presence of significant linguistic and cultural minorities, but in the case of Sicily it was to calm down separatist movements. The other 15 regions were in practice established in 1970, even if their ideation had been a much earlier idea.